Good morning, ladies and gentlemen. I'd like to welcome all of you to this workshop in the last of the month. Sir, can you switch off your mobile, sir? It's organized by IPPAI along with RE Connect and Bloomberg TV. It is the last of the 4 legs that we have done in India. Delhi, Mumbai, Calcutta, and now it's Bangalore. I'd like to also very special welcome to Mr. Naganan, Senior Counsel, Advocate, and right next to him is a person who doesn't need an introduction. It's Mr. Professor S.L. Rao, who is a prolific writer, a cerebral thinker, the first chairman of the Central Electricity Regulatory Commission, and a person who has been on the Prime Minister's Advisory Committee, and I can go on and on talking about him, but I won't take too much of the time introducing him. He's a terrific person who has supported the movement of IPPAI and its initiatives over the number of years. Electricity Act Bill Amendment 2014, now 15. The first question that before we get into the nuts and bolts of it, ladies and gentlemen, is why are we amending an act which was already passed in 2003? So obviously there is something wrong somewhere, and we'll get into the nuts and bolts of the issue. But before we start, I need to ask myself the first question, that we are Independent Power Producers Association of India, means private sector. Now private sector, I don't know the Kannada version of it, but private sector in the rest of India is chor. What is it in Kannada? I don't know. Allah. Kalla. Okay. So private sector means Allah. That is the mindset in the mindset of the bureaucrat, and that is in the mindset of the judges, with due respects, lots of judges, I'm not saying all, and that is in the mindset of everybody sitting in any position of power today. And the funny part is, 21st century justice is not in courts, it's not by trial, it's by media. So all I have to say, you are so-and-so, I accuse you of so-and-so, and that's it. It's a media trial, it's over, out, done with, everyone has jumped to conclusions, your name is ruined, nobody wants to know you. But I want to go back very quickly into history for 1 minute, and I want to tell you that while we talk about public good versus private profit, please understand that in the 1840s, and I'm quoting, there was a revolution in Europe, 1848 to be precise, in which Karl Marx wrote. The revolution that broke out across Europe that spring, he then in reaction published the Communist Manifesto. And the reason for this revolution was, in any case, capital prospered in the 1840s and industrial profits rose while labor income stagnated. So the disparity between the rich and the poor expanded. You had the French Revolution, you had the Russian Revolution later, you've had the fact that Karl Marx sat down to write the Communist Manifesto. But please remember, electricity was invented, financed by private sector. The telegraph service, which was the way to communicate in the world in the 19th century, was invented, financed by private sector. The railroad system, whether it is India, United States, was financed by the private sector. The steam engine was invented, financed, and ultimately brought onto ships to make trade move across the world, was financed by the private sector. So the infrastructure that we see today in the developed world, and we are all running towards that same infrastructure model where we want to have smart cities and we want to have smart this and smart that and smart grids and whatever, is all being financed by private sector. So the position of the private sector in the Western mindset where we have development is not that of a chore. It's a very important contributor of risk and reward, and if he takes a risk, he expects a reward. And that is not the situation, ladies and gentlemen, in the Indian context, and that is what I want to insist, that one of the reasons why we are not getting anywhere in the power sector is that it is still not very clear in the minds of policymakers, stroke regulators, stroke the general public, that what is the role of the private sector, whether it is electricity, water, telecom, airports, you name it. Now to the Act. Now, public-private partnership, a mindset of people needs to be changed. Why? Because right now we are having CAG audit of the private distribution company sitting in Delhi. So the Comptroller and Auditor General of India is now auditing their books. Now there is nothing wrong with auditing, but there is a slight catch here. Why should the CAG audit the books of a private sector company? Question number one. Question number two. Why should, after the regulatory commissions have gone through a fine-tooth comb into the accounts of those companies, and it's highly regulated, and they've allowed all this expenditure to be made, the CAG should comment on it. So today you have a gridlock in Delhi where the CAG is asking for information from the private sector company. The private sector company is saying, ask the regulator. And the regulator says, we have nothing to say, because we are a quasi-judicial authority. You can't ask me questions. I'm the judge. If I'm a quasi-judicial authority, who are you to ask me questions? I have gone through the process. Here is the process, gone through public process, etc., etc. What is the message you're getting? That a public-private partnership means that you are now going to be intruded upon by the state. What does that mean in terms of money? What is it in terms of private sector? It means that I, as a private company, as a private enterprise, cannot work transparently, legally, only for profit. Somewhere along the line, there are things like corporate social responsibility, morality, pricing, etc., etc. And therefore, the government expects me to do things, perhaps, which I'm not supposed to do. There is a demand for transparency in judicial activism and changing perception, a major change. Why? What's the problem? You have got an income tax law which has been amended retrospectively 60 years to 1962, only to make sure that you capture some revenue from Vodafone. What is the result? Everybody has left India. And there's lots of litigations. Then you have, of course, the 2G scam, which is still unraveling, and I'm still trying to figure out what's going on. But whatever it is, I'm not an expert. Mr. Naganand will share some thoughts on it, I hope. But the fact of the matter is that the telecom sector, every chaprasi, dhobi, garbage carrier had a mobile phone and he was able to use it. But ultimately, if you're going to start auctioning things, then the cost of service to the consumer will go up. And then what you find is the Colgate scam. Now what's the scam? The scam is that some people are allocated coal blocks through without proper minutes and without a process. So there should have been transparency, which is fine. But how much transparency? It's a government policy to give it free. And the Honorable Supreme Court has upheld the CAG's calculation of 195 rupees or some fancy amount like that, or 290, is it 295? Yeah. 295 rupees per ton as penalty for those who performed. Those people who actually got the coal blocks, spent the money, started working on it, which are very few, they should pay a penalty with retrospective effect. Those fellows who did nothing and just got the allocation, and they got away scot-free. So I mean, what is the signal we are sending as far as public-private partnership is concerned. And today's meeting and workshop, ladies and gentlemen, is not a talk-down. It has to be interactive. It has to be something where we really come up with clarity on thoughts on where we are going forward as a country and as a sector. I've already said public good versus private profit, sanctity of contract. I will leave to Mr. Naganan. The less said, the better. Today, everything is open for scrutiny and for review in public interest. Now, whatever that means. Everything. So, the point is, there was an article yesterday, was it today, I don't know, yesterday, saying that these coal auctions that have just taken place, there's something wrong with them. So now somebody's moved a petition, and I'm sure my friend Sakya Chaudhary will talk about it. So now we just gone to this coal auction, everyone's saying fantastic, we've got 2 lakh crores, we got the auction, now the coal blocks are coming, everything is done, allocations. 2 things happened. The process was wrong, somebody has challenged it. Second, if you read Times of India front page yesterday, a particular company's coal blocks have been awarded and withdrawn. So it's very arbitrary as to what's going on. So there is policy and regulatory uncertainty, and if you look at the hippopotamus, and that is the state, and you see the little chimpanzee, that's the little private sector. The basic issues that needed to be addressed, and I'll run through this very quickly, is sanctity of contracts, availability of fuel, railway port constraints. It's all right to say import coal, but there's no point importing coal because the coal is lying in the ports. The railways can't evacuate. Falling PLF levels, stranded capacities for transmission congestion, PPA issues, SBD1 versus SBD2, transmission bottlenecks, of course, I already said, lagging capacity addition. You need 1600 megawatts to be, or thereabouts to be added every month to meet the 13th plan target. That's not happening. There's nothing in the pipeline. Mounting financial losses of distribution companies, and so on and so forth. State discoms, this is a newspaper cutting, seek 26% hike in power tariff. Hello? Look what's happening. And this has got nothing to do with the impact that the new things are going to talk about. So we as consumers are going to be really paying more for all of this nonsense which is going on. And so we need to discuss that. This is the Economic Times. Then there's a panel to quiz the coal mines on reverse auction for power sector, is exactly what I mentioned. That's again on the March 16th newspaper of the Indian Express. Is there consumer choice? Cheaper power, efficiency, competition, reliability. There's not much of that has happened. All you got is higher and higher tariffs. And so what's the reality? Open access denied, discriminatory behavior, high cost of power, and so on and so forth, standby, exorbitant open access charges. And before that, we had this whole concept of promoting and enabling competition as one of the key objectives of the Act. Have we done that? Can a consumer sitting in Banglore buy power from Assam Electricity Board? Can he buy power from Bangladesh, or can he buy power from Punjab? The answer is no. Why? That's the matter of debate. So open access has not really taken off. So 2003 Act seems to have failed here. Consumer-wise, the idea of competition, the idea of bringing in efficiency, the idea of bringing in investment, the idea of bringing in market forces seems to have failed because the state is not willing to withdraw. Now, what are the key provisions of the amendments proposed? Very quickly, we'll go into it. There's a lot of documentation, a lot of ground to cover. There's, of course, promotion of renewable energy sources. My question to you is this: how do you how do you schedule renewable energy in 15-minute time blocks when the wind is not schedulable, and nor is the sun, nor is the clouds, if for want of a better word? So we want to promote renewable energy, but at what cost? And already we can't pay the costs that are there of cheap power. How are we going to pay for renewable energy? Regular revision in tariff, they've talked about identifying the need for decentralized power distribution. Good idea. You'll cut down your tail end losses. Smarter grids and ancillary services. Great idea. Tariff to ensure recovery of cost of electricity without revenue deficit. Very good on paper. Let's see how it happens. It hasn't happened so far. There's a focus on grid security, grid discipline, etc. The spinning reserves, great. Renewed focus on open access and its implementation. Focus is there, but whether that focus will become hocus pocus or actually become focus and do something, we have to see. Structure, function, and accountability of regulatory commissions. There's a whole stuff, which there's a whole session on this in the afternoon. The whole idea of regulatory commissions themselves are being questioned, and the way their authority, I think that is not fair, because at least the day-to-day, we have these specialized bodies which are looking into electricity, which is a complicated subject. Every Tom, Dick and Jack, I'm not using the word Harry because of me, can't you do it? So you need these bodies, but now you're questioning their credibility and independence. And I have underlined this: separation of content and carriage in electricity distribution business is the most controversial. And just after the inaugural session, we are going to have a talkathon, if you like, between myself and my friend Sakya Chaudhary on these issues. Some points that need attention. There's no direction for clearing congestion of transmission lines. The South is still suffering. There's huge amount of surplus stranded capacity. South India has, I don't know if you looked 4 days ago, the price of electricity on the exchange in S2 was 20 rupees. No plan, and that's at the bulk rate. So no financing of transmission projects in sight. Incentivizing of hydro projects through HPO is missing. Allied infrastructure support in rail, ports, movement of fuel, there's no coordination. Scheduling of RE is still a challenge. Power storage should be promoted. There's no mention of storing of power. Then there is the no amendment proposed in section 11. Some states misuse this section to cut down whenever it suited them open access transactions without actually paying for the consequential damages and so on and so forth. There's no direction on revival of stranded capacity, and what I don't see here is regulatory assets. Now, very quick, the last thing I will need to go into before I'm going to invite Mr. Naganan to speak, because he has to run along, is separation of content and carriage. Now, in the existing DISCOM, you are now going to have a holdco and a wire company. So basically the distribution company, in theory, becomes an extension of power grid. Okay? So power grid right up to your house. And then there's going to be a holdco, which is in poor financial health. And there has to be a government company, which will have the USO obligation, so which may be the holdco, may not be the holdco, not clear. Then you have these other supply licensees who are supposed to be power traders. But the question then comes, if that's going to happen, then there are a huge bunch of issues. And what are they? Delhi has regulatory assets of 27,000 crores. This is the private sector chaps, recognized assets. Where will all these assets go after separation of carriage and content is done? Who will pay for it? Again, a power tariff increase, or is there some magic solution? If the assets are given over to the wire network company, or if the assets are parked with the USO obligated licensees serving consumers below 1 megawatt and below, he can't charge those guys. Those guys are below the poverty line, they're poor consumers. The company will have to increase the wheeling charges to meet the regulatory assets. Is it so? The USO obligated entity will have to be given subsidy through some means, or will they increase the tariffs again? So who will be the owner? And so on and so forth. Now it's very interesting. I'll just throw 2 points and then I'll stop on this because we'll discuss it in detail. Tata Power Company in Bombay and Calcutta Electric Supply Company in Calcutta both have generating assets embedded in their distribution network. And it says that the USO obligation will fall on this organization, which has to be government owned. So that means now Tata Power will be broken up into 2 parts, wires and supply. And the supply will then become a government company, which means you remember what I said about private company? Keep that in mind. Now will become a government company because it has to be this thing of the last resort, etc., etc. Same thing with Calcutta. Open access, consumers with load of 1 megawatt are deemed open access consumers as per the bill, as per the act, after some date, not happening. Cross-subsidy surcharge to be applicable only for open, not in the case of migration to other supply licensees. It's not clear to whom the CSS would be paid. If I migrate from one supply licensee to another, then there is no CSS. Is that a fact? Why should it be so? Not clear. Because they are beyond regulations, they may be subject to all kinds of charges. 11 was misused, I mentioned, matter is sub judice. Rationalization of tariff. Now SERC to set a ceiling tariff for each category. We are talking about market forces, bringing in investments, competition, private sector to augment generation, transmission and to privatize distribution. But SERC will now set up a ceiling tariff for each category. So SERC has to now do a study to figure out what should that ceiling be. And where is the competition if ceiling tariffs are set and everything is regulated? There isn't any. Power for suo motu proceedings in case of delays in filings, provision for national tariff policy, very important to be made mandatory, and I hope the minister was here on this one. Provisions of the national tariff policy will be made mandatory for states to follow. So remember, now we are fiddling with the federal structure of this country, where electricity was and is a concurrent subject. So this will be strongly opposed by states as electricity is a concurrent subject, and let's see what the reaction is. Failure to comply with RPO will result in penalties. It's been from 1 lakh to 1 crore for violations. Renewable generation obligation. Now, if I set up a thermal power plant, I also have to set up a renewable energy power plant. Question is, who do I sell to, at what price, what is the tariff, how will I do it, who will pay it, how will I finance this, meet this RG obligation, and so on and so forth. Grid security is a positive step. There's a very interesting one here. This is for distribution companies and the state players. Intrastate trading margin to be fixed by SERCs. Earlier on it was if necessary. What this means is the distribution company, which is a deemed licensee in the state, if it sends off power into the UI or sends off power into the power exchange or sends off power into the system, it must have a margin. Now, as you know, power exchanges run on a market clearing price. They don't run on trading margins. The UI can keep going up and down depending on the demand-supply gap. So how is this going to be implemented? I don't know. Fixing intrastate margins, regulatory assets, and then section-wise so and so. So this is all lying in your documentation. I'm not going to take too much time. I want to ask now Mr. Naganan to start with his remarks while we proceed. But if you have important questions, don't hang around, wait for the rest of the world to fall and then just raise your hand, we'll get a mic to you. Mic walas, be ready. Mr. Naganan, over to you, sir.